Welcome to this book talk organized by the University of Hong Kong Center for Comparative and Public Law. I'm Cora Chan and I'll be the chair of today's session. Today we gather here to celebrate and discuss Professor Kent Roach's new book, Remedies for Human Rights Violations, a two-track approach to supra-national and national law, published with the Cambridge Studies in Constitutional Law series earlier this year. We're immensely honored to have with us today the author, Professor Kent Roach, Professor of Law at the University of Toronto Faculty of Law, who will speak to us about his book. We're also very pleased to have Professor Yap from the Hong Kong U Law Faculty and Director of the CCPL as discussant. Professor Roach really needs no introduction. He's one of the world's most distinguished scholars in public law and criminal law. Professor Roach has been editor-in-chief of the Criminal Law Quarterly since 1998. In 2002, he was elected a Fellow of the Royal Society of Canada. In 2013, he was one of the 4 academics awarded a Trudeau Fellowship. And in 2015, he was appointed a member of the Order of Canada for his contribution as a scholar and advocate to human rights protection. He's the author of numerous award-winning books and has published hundreds of articles and book chapters around the world. His work in particular, I would like to mention on this occasion that his work on remedies, amongst other subjects, has been cited widely by the courts, and he has acted as counsel on a pro bono basis in many of the Canadian Supreme Court's landmark decisions on rights remedies. I myself have benefited enormously from Professor Roach's writings on constitutional remedies, counterterrorism, and judicial activism. So it's a real delight for me to be able to chair this talk. This book is a groundbreaking treatise on the neglected topic of remedies in human rights law. It proposes a twin-track approach that seeks to provide both individual and systemic relief. It also argues that the proportionality principle should be applied at the remedial stage to make remedial decision-making more transparent and structured. And as part of its twin-track approach, the book advocates for some non-conventional remedies, such as what Kent calls the declaration plus, as well as consensual remedies. What I find really valuable about the book is that the proposed framework is illustrated extensively with jurisprudence from international as well as domestic courts, and is applied to various human rights contexts. So not only are the proposed framework and principles insightful, but after reading the book, you also get a concrete sense of how they could be applied. As with Kent's other writings, the analysis is systematic, rigorous, and thorough, and it's elegantly written, very clearly presented, and accessible even to non-experts. So many congratulations, Professor Roach, on this masterpiece, which will be an illuminating guide for judges and scholars around the world. Let's begin by inviting Professor Roach to speak to us. Kent.
Well, thank you very much, Cora, and thank you to the center. Cora, you're much too generous, but it's very much appreciated. As Cora Chan has mentioned, remedies have been, I think, perhaps neglected in public and comparative law scholarship. Of course, there are some very important exceptions. I speak about, the legacies of Edwin Borchett, who I think needs to be better known than he is, an early and fairly rare for an American comparativist. Abram Chase also plays an important role in this book, and I had the privilege of studying with Owen Fiss. So there are people that have looked at remedies, and of course your own Professor Yap has also featured remedies in his scholarship. There are some books on declarations of incompatibility. So I hope that this book encourages more scholarship on remedies in public law. I also think, and again, this follows from what Professor Chan said, that remedies provides a very interesting look into comparative law. This is a point that Dean Robert Leckie of McGill has also made, and he's also a person writing in Remedies who has influenced my work in part through his critique of some of my earlier work. And so, the point is, I think that if you look at Remedies, you take a much more nuanced and focused approach to comparative law than if you simply look at rights and perhaps justifications. And I'm still amazed at how many books in public law on human rights laws either omit remedies or have a fairly perfunctory chapter at the end and really don't integrate them in a way that is central. So one last methodological point before I move towards the main thesis of the book is, let's take Mark Tushnet's very influential distinction between weak and strong form judicial review. If we examine this through the lens of remedies, we start asking, I think, more nuanced questions. So those of you who are familiar with American constitutional law will know that although there are facial declarations of invalidity, which strike a law down in its entirety and are, perhaps the paradigmatic example of strong form judicial review, much of the American practice has moved towards narrow as applied forms of invalidity that essentially say this law, this democratically enacted law, is constitutionally invalid and no force and effect, but only on the facts as presented in the particular case. And of course, that approach to constitutionality, one that's consistent with what Cass Sunstein has called judicial constitutional minimalism and deciding one case at a time, flows over into other areas of remedies, most importantly, qualified immunity. So one of the reasons for qualified immunity, which has become obviously quite controversial in the United States in the wake of George Floyd's death, is the idea that there is a presumption of good faith unless there is a clearly established precedent on rights that the police officer or correctional official or other member of the state is violating. And so if you have as applied case by case minimal declarations of invalidity, that then flows in and nurtures qualified immunity. And so all of a sudden, although the United States does allow courts to invalidate democratically enacted laws, the simple dichotomy between strong and weak form judicial review becomes much more complicated. So I would urge students of comparative law to think about remedies. The last kind of methodological point is that this book, which very much reflects two terms where I was really privileged to teach at the Center for Transnational Legal Studies, which is a wonderful program in London, England, that brings together students from around the world, really is really, I guess, my second engagement with supranational law. And I'm particularly interested whether international lawyers will read the book. I hope they do. They may critique my approach to international law. I recognize that I'm a newcomer, but I see international law as part of public law. And of course, teaching in a jurisdiction where the European Court of Human Rights is available, really underlined that lesson to me. So obviously international law has different purchase in different parts of the world. Most of my examples are taken from the European Court of Human Rights and the Inter-American Court of Human Rights. But even my own country in Canada, we don't have access to the Inter-American Court of Human Rights. I wish we did. And this kind of builds on an early and brief mention that I made in my dialogic or my dialogue scholarship, that one of the features in Canada when we use the notwithstanding clause with respect to a language to promote the French language in Quebec was that some of the Anglophones who were offended by a law that essentially prohibited the use of English in public signs took their case to the United Nations Human Rights Committee at the time, Council now. And although those decisions didn't receive an awful lot of play, they were decided in the favor of the Anglophone merchants who, like the Supreme Court of Canada, said that there were more proportionate ways to protect the French language than a total ban. And of course, after 5 years, when the notwithstanding clause under the Canadian Charter expires, the Quebec government decided not to renew it. I wouldn't say that international law played a major role in that, but I see this as part of the dialogue. That is, when there are no remedies available, when they are requested and denied at the domestic level, I think the next step is to ask for some sort of remedy at the supranational level. So now moving on to what's really the central argument in the book is the two or twin track approach that Professor Chan mentioned. And again, you find this fairly routinely in supranational law, so that most decisions of particularly the Inter-American Court of Human Rights and the United Nations Human Rights Council will say there is a specific measure, which is a measure for the applicant, and will usually be a form of damages, looking to recognize the human rights violation and to attempt as best possible to repair that. But then there is a general measure. And the general measure is to prevent the repetition of the offense. And in supranational law, the courts are much more prescriptive at times about the specific measure, calculating damages, providing protection in some cases for the applicant. Sometimes the applicant will have received an interim measure, which is also something that I see as a very important and understudied a specific measure or individual remedy. But courts, supranational courts, are quite deferential to the ability of the state, the member state, to fashion from a range of different policy alternatives what the general measure to prevent the repetition of the violation is going forward. And they see this as part of subsidiarity, respect for the nation state. Something I argue in the book, perhaps controversially, is somewhat analogous to the domestic doctrine of the separation of powers. Now, you may think this is all very weak, and I thought Professor Roach was an advocate of human rights. Why is he looking to international law, which is kind of known perhaps more for its weakness than its remedies? But the other thing that I really admire, and this is particularly the case of the Inter-American Court of Human Rights, is that those courts have a staying power. That is that they will frequently retain jurisdiction over over a matter and ask the nation state to report back about what, if anything, they have done. Sometimes they ask the nation state just to publish the judgment, which may seem like a trivial thing, but I think potentially significant. And one of the things that has struck me about supranational courts is that both the San Jose and even the Strasbourg courts are very under-resourced, and they have their own institutional interest in preventing repetitive violations. And I compare this to, rich democracies like my own, where the courts are very diffuse and are somewhat shy about using non-repetition or deterrence as a remedial construct. In the United States, they're less shy, but certainly in Canada and in England, I think they're generally shy. But each court seems to often see repetitive violations. And I experienced this as a litigator when in 2001, I was involved in a case that put fairly significant restrictions on police use of strip searches. And subsequent to that case, over 100 trial judgments found that various police forces in Canada were ignoring this constitutional rule. But they simply dealt with the case on an individual basis, sometimes excluding evidence, sometimes even staying proceedings. But the police continued, at least in those police services that did not have training and internalized the rule, they continued violating people's rights against unjustified strip searches once those people have been arrested. So I really developed an admiration for supranational courts and their ingenuity in saying to the state, you have to do something. It could be executive, it could be legislative, it could be educational, but you have to do something to ensure that this violation that we've identified and that we've provided a backwards specific measure for is not continued to be violated. So how would this play out in the domestic context? So this is probably the heart of what people are interested in. So let's start off with the suspended declaration of invalidity, which is a remedy that is used frequently in Canada and South Africa. The two-track approach, and as I was finishing the book, I was really fortunate that the Supreme Court of Canada came down with the Ontario versus G decision, and it was the last thing I was able to include in the book. And I had also acted as counsel for one of the interveners in the case, said that we will continue to suspend declarations of invalidity, despite the important criticism that Robert Leckie and others have made. But we will generally exempt the applicant from the effect of the suspension. And so in the G case, this was a person who found himself on a sex offender registry with all of the bad stuff that comes with that, even though he had been found not criminally responsible and had received an absolute discharge on the basis that he was no threat to commit a sexual offense, and he had a very clean record for, I think, over a decade. And so it seemed to me that this is what in accordance with the separation of powers we want to do. That, since Blackstone and Dicey, we do expect courts as a place that gives aggrieved people meaningful remedies. So Mr. G got his remedy. He was taken off of the registry. At the same time, the decision about who is on the registry and how do you deal with perhaps the odd case, that is, people not convicted of sexual assault but found not criminally responsible, that raised policy issues that at least the legislature should have an opportunity to address. Now, it turns out that the legislature probably will not fill this vacuum, and that the invalidity will take place. But I do think that this is an appropriate approach. And I think that this is an approach that is somewhat less problematic than the South African approach, where when they suspend a declaration of invalidity, they come up with general guidelines to guide the executive during the 12 or 18 or sometimes even 24 months of the suspended declaration of invalidity. Now, don't get me wrong. I think courts that suspend declarations of invalidity have some responsibility for what happens during the suspension. But what I worry about is that when the court fills the policy void, that may short circuit legislative policymaking, and the executive is obviously involved with that, and kind of provide an example of a human rights proof, pre-judicial approved body of law. Two other kind of twists on the suspended declaration of invalidity, I think, are also relevant. In Hong Kong, there is a distinction between a suspended declaration of invalidity and temporary validity. And Pojan and Cora and others have written about this. I would see the temporary validity as more consistent with the spirit of the two-track approach, because at least it opens up the possibility for damage awards should the executive abuse the powers under the law that is given temporary validity. Although I think the Irish approach is actually probably the best. And interestingly enough, the Irish approach involves a declaration of incompatibility. And I think one question in Hong Kong is whether, following the New Zealand Supreme Court, should Hong Kong courts think about making declarations of incompatibility with the basic law and the ICCPR, even though they may not have the power, for example, with respect to the national security law, to invalidate the law. But that's a bit of a provocative aside. So what the Irish law provides, and again, it's not perfect, is that when the Irish courts make a declaration of incompatibility on their Bill of Rights, largely now based on a statutory Bill of Rights, I think, based on the European Convention, there's also a possibility for damages to be awarded. And again, I think that this is consistent with the two-track approach. The last example from Remedies for Unconstitutional Laws, which is Chapter 4, is the use of prospective rulings. And of course, the United States Supreme Court, the Warren Court, used these quite a lot when it was making fairly sweeping civil rights rulings. And again, I would argue that this is a sign that the two-track approach is not just theory, but also something that is present, at least in some of the law, but perhaps under-theorized. And that is when a prospective ruling is made by the US Supreme Court, they usually give the applicant, and this has been the case in Canada, the immediate benefit of the ruling, while saying that the rights violation will only apply prospectively. And so again, this is kind of a way that courts can make bolder rights declarations while not unsettling established jurisprudence. And I talk about the Hislop case, which is Canada's leading case on prospective rulings. And you know, part of my sensitivity to these issues is the fact that I have been involved as a litigator in many remedies cases, because typically when I'm asked to help with a case, it's by litigators who are pushing the rights envelope and want to make sure that they don't open themselves up on their remedial flanks. And frankly, part of my role is to have a meaningful remedy that's not too weak, right? But also not too strong. So I kind of bring a litigator's sense to this, even though my university thinks that clinical work is non-academic. But that's, again, another provocative side. So what are examples of the two-track approach outside of remedies for laws that violate human rights? One is, and I had the great pleasure, and it was really an honor to meet with him several times. A decision by the great South African judge, Justice Albie Sachs, and it was a housing rights case. And you know, those of you who are familiar with the South African Constitution will know that the South African courts have been, I think, you know, fairly concerned about overpromising when it comes to socioeconomic rights, and it's partly because they live in a world where inequities are very visible, and someone like Justice Sachs really sees that. But in this case, it involved a housing rights case, and Justice Sachs came up with what I would call a twin track remedy. So the twin track remedy was, he said, you know, we can't solve all injustices, but we're going to solve a micro injustice by ordering that this person not be evicted from their temporary housing, a kind of squatters housing. And we're going to do that because that's what they've asked us, and they've made their case to the court, and they deserve a remedy. But with respect to the macro injustice, the court says we can't solve that, but we are going to order or urge the government to engage with the homeless and the underhoused to come up with a kind of public housing method going forward. And this is very different than in its early socioeconomic case, where they disparage the individual person asking for a remedy as kind of a queue jumper. Right, so one of the very first cases that they dealt with was about healthcare, and I know that, you know, in Canada we also have that sense: is why does the litigant get to jump the queue? Well, the answer for me is that it's because the litigant has a right to a remedy. Now, the litigant may be more advantaged than other people, but, you know, queues are only one way to allocate scarce resources. That's something that Guido Calabrese, my teacher, taught me. And so, like others, I think that we need both an individual remedy, even if in the broader socioeconomic picture, it's a regressive remedy, but we need that in order to mobilize public support and to make visible what it is to be evicted from your temporary house, or what it is to be denied life-saving treatment. And I think that that's what courts bring. And I think, if you look at Charles Yap and others that look at David Cole, that look at the role of courts in combination with social movements and legislative amendments, this is also consistent with it. What would a two-track approach look like in kind of the policing context? Well, there's a New Zealand case that I think is really kind of an elegant example where basically the police beat up a person in detention, and the New Zealand courts, as is their wont, award fairly significant damages. But they just say one thing at the end. They said these damages would have been much greater had the state not presented evidence that the police officers had been appropriately disciplined. And to me, that's kind of an elegant, light touch saying, look, we are going to remedy the past, but we also don't want a repetition of the future. And if courts did that in exclusion of evidence cases or whatever, you wouldn't have to say the only reason we're awarding this remedy is for deterrence, which tends to be what the American courts say. But you could say, yes, we're awarding this remedy for compensation, but we're also concerned about deterrence or repetition. And so part of my argument is that if we only focus on the compensatory approach, we're going to ignore the larger context in the bureaucratic state. Conversely, I argue if we only concentrate on systemic reform, then as has happened in some Indian public law litigation, the litigation will lose its focus, and it will become more about the courts and the amicus curiae, and may very well, as Derek Bell remind us in his seminal work, Serving Two Masters, that many people think was the start of critical race theory, may very well have a systemic remedy, desegregation, that does not serve the actual applicants as well as they can. So that's really all that I want to say. I will add that the book was already long, but after I finished the book, I did a chapter, a separate article applying the two-track approach to climate change, which I think is the 21st century's version of Brown versus Board of Education. And so if anyone wants to ask me that or get a copy of that, it should be out within the next few weeks. But that's kind of chapter 12 of the book. So thank you very much.
Thank you so much, Ken. Lots of food for thought. We'll now have Professor Yap to deliver comments on the book. Professor Yap is an expert on a wide range of topics, including constitutional dialogue, constitutional remedies, proportionality, and courts. He's the author of Constitutional Dialogue in Common Law Asia, published with OUP, and Courts and Democracies in Asia, published with CUP, as well as the editor of Constitutional Remedies in Asia, published with Roach, and Proportionality in Asia, published with CUP. Thank you, Pojan. I'll hand over to you.
Thank you, Cora, for the introduction. And of course, we all like to thank our guest today, Professor Ken Roach, for giving us a first-hand account of his book and his writing experience and the labors of bringing this to production and in print. I think he has summarized his book very well, so I will not traverse the same point, but I would just like to just repeat his core insight and contribution to the literature. So I think Professor Roach has convincingly argued that courts should use a two-track approach to remedy violations of human rights. The first track is specific relief for successful litigants to correct individual wrongs suffered. But Kent further argues that the first track must be complemented with a systemic track that rely on the government's superior institutional expertise to craft a comprehensive, forward-looking, long-term legislation that addresses polycentric and resource allocative concerns. Kent's core arguments that both remedies should run at the same time. Judges should not just choose one. And I think this is one of the most important arguments put forward, I think, on the topic of remedies. Right? So for systemic remedies, what Ken refers to in his discussion and in his book is that there are two main kinds. Right? One is advisory declarations of unconstitutionality. We see that in the UK under the HRA, where the UK Supreme Court may not strike down legislation for being unconstitutional. And the second are delayed declarations of invalidity, where the law becomes unconstitutional after a time period. Type 1 advisory declarations does not exist in Hong Kong, but we see that in Korea and Taiwan. So I think today in my discussion, what I will do is to focus on how Kent's theory and core arguments apply in Hong Kong and the region we live in, East Asia. In Taiwan and South Korea, I think what's really interesting is the Taiwanese Constitutional Court has resorted to all these advisory orders in highly divisive, highly politically controversial showdowns with the other branches of government. In Interpretation 419 in 1996, the court had to decide whether Taiwan's Vice President Lian Zhan could simultaneously serve as the Vice President and the Premier at the same time. At the time, Kuomintang controlled both the presidency and the legislature, and all the justices on the court were appointed by President Lee Teng-hui himself. Therefore, the justices had not only to confront a president and his legislature in lockstep, they had to stare down the very president who appointed all of them. One justice even disclosed later, after the controversy blew over, that the KMT had attempted to lobby him privately in the middle of the judicial proceedings to rule for the president. In the face of such monumental political pressure, the Taiwanese Constitutional Court euphemistically ruled in the judgment that it will not be completely in conformity with the Constitution to have the Vice President serve simultaneously as Taiwan's Premier, because the Vice President might act on the behalf of the President on occasions, and there's a certain check and balance function between the President and the Premier. But interestingly, the court did not strike down the appointment outright. Instead, the court just left the decision as it is. But interestingly too, 8 months after this decision, Lian Zhang resigned the premiership, but he stayed on as Taiwan's vice president. Interpretation 601/2005 was another landmark decision where the TCC ruled that the government's practice was unconstitutional but did not impose a deadline for compliance. In 2004, there was an attempted assassination of President Chen on the eve of his re-election. The KMT believed that assassination attempt was staged by Chen Shui-bian to gain sympathy votes prior to the election, and they created a commission to investigate this assassination attempt. But many key parts of this commission were struck down by the TCC for interfering with prosecutorial and judicial functions. After this adverse ruling, the KMT-controlled Legislative Yuan decided to punish the court by removing the bonuses from the judges' remuneration. And the TCC held that this removal of their bonuses violated the Constitution's protection of judicial independence. But prudentially, again, the judges did not impose any guidelines or deadlines on how they should be reimbursed for the bonuses taken away. Eventually, the legislature caved and reimbursed all the judges the next year. In South Korea, The Korean Constitutional Court has also issued suspension orders that do not impose deadlines for compliance. In 2005, the court declared a patriarchal law which subordinated a woman to her father, to husband if she were married, son if the husband were deceased, was incompatible with the Constitution, but it merely asked the legislature to amend the law as soon as possible. South Korea is a modern constitutional democracy, but is deeply steeped in Confucian tradition. And the KCC chose to tread carefully as they attempted to reform reactionary social mores. But this calibrated show of force bore fruit, as in all these cases, the National Assembly eventually caved and passed remedial legislation to comply with the decisions, although no fixed deadlines were first imposed. But more common is the delayed declaration of invalidity, which we see in Hong Kong, Taiwan, and South Korea, where a fixed deadline is added to the suspension. More interestingly, in East Asia, these three courts have added a bite to the suspension orders, such that judicial safeguards are imposed to the delayed orders to mitigate any governmental delinquency. When the KCC declared that it was disproportionate for the state to prohibit all persons with the same family names and lineal origins, regardless of the degrees of consanguinity for marrying one another, the court prohibited the state agency from applying this law while giving time to the legislature to remedy the situation. So what happens in South Korea back then was there was a law saying that if you have some common ancestor on the father's side back in the Joseon dynasty, which was in the 15th century, you can't marry one another in the 21st century. And because sorry, that's not constitutional, right? But, so while giving time for the legislature to fix the law, right, they enjoined the state agencies from applying it. As for Hong Kong, the Hong Kong CFA has also issued suspension orders so that the Legislative Council is given time to pass corrective legislation. But what is unique about suspension order in Hong Kong is as follows. This is what the court said. The government can, during the period of suspension, function according to what has been declared unconstitutional. But despite such suspension, the government is not shielded from any legal liability during the period. In Kuzi Yu, the suspension order was first granted because of this law that allowed the chief executive, whenever he or she considered a public interest so required, to order interception of any telecommunications. The CFA was reluctant to hamper legitimate covert surveillance, which will result from an immediate invalidation of the law. But the court was also unwilling to give the government free rein to do as they pleased during the period of suspension. Therefore, this suspension order granted the government officials the power to continue to engage in covert surveillance while the law was being revised, while not immunizing them from any legal liability if they abuse their authority during the suspension period. I think what is even more remarkable Hong Kong and Taiwan is that the courts have coupled their use of the delayed declarations of invalidity with a remedial reading in if the government doesn't comply at the end of the suspension period. So the suspension order coupled with this remedial bite was first issued by the Taiwanese Constitutional Court when it declared that Taiwan's ban on same-sex marriage was unconstitutional. The legislature was given 2 years to remedy this legislative exclusion. But notably, the court also held that if Taiwan's legislative yuan defaulted after the deadline, same-sex couples would be entitled to apply for marriage registrations automatically. And it was also systemic in the sense that the TCC held that it was within the government's discretion to determine whether same-sex marriage should be regulated under a separate statute, under a new chapter within a pre-existing matrimonial law, or whether the pre-existing matrimonial law should just simply be amended to be made gender neutral, right? So that allows the government leeway to decide which remedy they want to choose. But if they don't do anything, there will be an immediate reprieve for the applicants at the end of the 2 years. Similarly, Hong Kong Constitutional Court, Hong Kong Court of Final Appeal, has relied on this remedy when it ruled in favor of transsexual marriage back in 2013. In W, the court held that the law prohibiting transsexuals from marrying in their quiet gender was unconstitutional, but also gave the government 12 months to fix the law. Interestingly, LegCo at that time refused to pass a remedial legislation, but the court also have held that if the government defaulted, then automatically transsexual couples will be able to marry by just going to the under the remedial reading of the pre-existing law. Interesting too, the TCC and the KCC have gone on even further to issue interim remedial readings of the unconstitutional law during the suspension period. So therefore, even before the suspension order lapsed, there will be an immediate individual relief for the applicant. So we see that recently with the TCC in interpretation number 720, and it was concerning the legislature's failure, long-standing failure, to allow pre-trial detainees to challenge the conditions of their detention. And the court held that pending legislative reform, pre-trial detainees could invoke the criminal code, which previously only applies to convicted criminals. But this code will now be used to assist pre-trial detainees pending legislative review. Similarly, the Korean constitutional rule that the law enforcement's statutory power to search without a warrant of the premise of any person was incompatible with due process rights. And the KCC decided that prior to any legislative revision, the impugned statutory provision may only be applied by law enforcement when it was probable that the suspect was located in the premises and it was an emergency situation. So they read in conditions to cabin the use of such searches while the law was being revised. So the judicial use of all this judicial remedial discretion may pose constitutional dilemmas for legal purists. But if we view governance as a field of partnership between the judiciary and the legislature, these innovative remedial strategies have the capacity to foster greater democratic deliberation and improve legislative and executive performance, for they conjoined the very best in statecraft and adjudication. So on this note, I would like to congratulate Professor Roach for writing this monumental, path-breaking, pun intended, monograph that has fundamentally reshaped our views on how rights interact with remedies. And we hope his prescriptions will be incorporated by courts in Hong Kong, East Asia, and around the world. Thank you very much.
Thank you so much, Pojan. Really helpful case studies from Asian courts. I think you and Professor Roach have convincingly established the importance of remedies as a device for balancing the various considerations that are at play in human rights adjudication. So I think we have about 10 minutes for Q&A. If any one of you have questions, you may type them in the Q&A box. In the meantime, perhaps I could start with a couple of questions that I have while reading the book. The few questions that I have actually relate to an aspect of the book that Professor Roach didn't manage to cover in his presentation, which is the application of proportionality at the remedial stage, which I think is very important and illuminating contribution, because it clarifies both the procedural and substantive principles that are applicable at the remedial stage, which I often find puzzling. So, but we're very clear on the procedural and substantive aspects in the limitation and definitional stages. But when it comes to the remedy stage, we're suddenly in this black hole. We just don't know what's going on. And so I found the analysis in your book very helpful in that respect. So the questions that I have, the first question that I have relates to the burden of proof at the remedial stage. There are actually two related questions. The first is, so does the litigant need to discharge any burden of proof at the remedial stage before the government is asked to show that the remedy it counter proposes is proportionate. The impression that I seem to get from reading the book is that for interim remedies, an initial burden rests on the litigant to show that there'd be irreparable harm if the interim remedy is not granted. And in the case of damages, an initial burden also rests on the litigant to show that remedies are a suitable remedy. But for all other remedies, so non-interim and non-damages remedy, it seems that once a rights violation is proven, the burden rests immediately on the government to show why the remedy it proposes is a proportionate one. I just wanted to clarify if this if my understanding is correct. And a related question to that is on the litigant's burden regarding the proportionality test. So it's clear that your proposal is that the government needs to demonstrate that the remedy the government advocates passes the four-limb proportionality test. But when does the litigant also need to show that the remedy which the litigant wants is proportionate as well? Because it seems that in the case of remedies, you mentioned that the litigant would have to show that the interim remedy goes no further than necessary. So how about in other situations, does the litigant need to show proportionality as well? So that's my two questions on burden of proof. I noticed that there are two other questions. Ken, would you like to first answer my question before taking those two questions, or?
Sure.
Yeah.
Sure. Yeah. So those are very perceptive questions. I think that you're right on both interim and damages, that there is some burden on the applicant. I think in other cases, the court has to be responsible, so could resort to some ideas if the litigant's requested remedy was, obviously disproportionate or unmanageable. But I really do think that in most of these cases, the burden should be on the government. You're right that I haven't drawn that out as perhaps clearly as I should have. But I think a lot of this is saying that, we all know that balancing of interest takes place within remedies. And although there are criticisms of proportionality with respect to rights, I think they don't really apply with respect to remedies, which are a form of practical reasoning. And I guess the last thing that I would quickly say is, for me, this really comes out of the Ward versus Vancouver case, Canada's leading constitutional tort case, where this kind of countervailing mini proportionality exercise was seen as an alternative to qualified immunity. So qualified immunity is another way of protecting the state's interests, but it does so in a much more blunter way, where it seems to me that proportionality gets to the heart of much remedial analysis, which is often, is this a case where damages are sufficient, or should there be an injunction, and also issues of overall balance. Now, Simon's asked about this case that is under reserve in the Supreme Court, and I actually have a student who's doing a research paper on that. I think that convicting someone of a law during a suspended declaration of invalidity is extremely problematic. And I worry that the court, which, kind of united on what I would see a two-track approach in Ontario versus G, is probably going to fracture on this issue. So I would prefer that that person not be convicted. I think that, in some ways this illustrates the Robert Leckie critique of suspended declarations of invalidity. But I really have no prediction with how the Supreme Court will go, other than I doubt it will be unanimous. I mean, I guess this is also perhaps a case where the South African approach might have avoided this problem. And this may actually be a limitation of the individual remedy, that the South African approach, I think, would have given clearer instructions to the police and prosecutors about how the unconstitutional law, I think it related to sex work, was to be administered. So that's a really difficult question, Simon. Thanks for asking me. This is one of the reasons why I like engaging with people at the University of Hong Kong. One of the things that I will say about Po Jen's, really interesting talk, and I should have used more of it. I mean, I'm not as familiar with the Taiwan and South Korean courts as I should be, but his explanation, I think, also goes to what I think is also an implicit message or explicit message in the book, which is that it's countries in the global South that, by and large, are actually delivering remedies. Sometimes with the dialogic twists that Po Yap has outlined, sometimes much more boldly if you take the Colombian Constitutional Court. And I think that to address the last question, I actually think that there is a sense of small L liberalism or right to remedy that is perhaps more alive in the global South than it is in the United States. And, if you go back to Marbury versus Madison, I think in some ways this may be the original sin of what in other work I've called American extra-legalism. Because although Marbury and Madison proclaimed the Blackstonian idea of a right to a remedy, the person who was denied his appointment received no remedy. Why? Because there was a legislative restriction on the powers of the federal court. And it always, again, to end where kind of I started with Mark Tushnet, I don't think the United States is a strong form judicial review as Professor Tushnet thinks, in part because of the record of American courts on remedies, whether it's in Marbury versus Madison, deferring to a legislative restriction on the court's jurisdiction to award a remedy, or with respect to the War on Terror, where the American courts have never granted damages, and it's been left to the European Court of Human Rights to grant damages, however inadequate they may be, for victims of American torture programs. So, I understand how there may be pessimism and even depression about the fate of rights, but I do think that at least for us who are privileged to live in Western democracies, it's surprising how often we are looking to the courts of the global South now for inspiration, as opposed to the courts of the most established democracies.
Thank you very much, Professor Roach. I see that it's 10 p.m. Po Jen, do you have any final remarks before we close Kent, any final remarks? Well,
no, just to thank both you and ProGen. You're very good friends and good colleagues, and I'm very gratified by the interest that you and all of the participants have showed in my work. Thank you very much.
Thank you very much, and many congratulations on the book again, which we'll all be reading and rereading again and again to draw.
We hope to see you in person soon.
Okay.
Yes, very much. So please join me in thanking our speakers, Professor Roach and Professor Yap. Thank you very much. And thanks also to the audience for joining us. We hope to see you at future CCPL events. Thank you.